Okay, so I'm going to be reading for publication United States Court of Appeals for the Ninth Circuit, Project Veritas Action Fund, Plaintiffs Appellants versus Michael Schmidt in his official capacity as Multnomah County District Attorney, Ellen Rosenblum in her official capacity as Oregon Attorney General, Defendants Appellees. And this is number 22-35271, DC number 3:30 CV 01435-MO opinion. Appeal from the United States District Court for the District of Oregon, Michael W. Mossman, District Judge, presiding, argued and submitted December 7th, 2022, Pasadena, California, filed July 3rd, 2023, before Carlos T. B. BEA, Sandra S. Ikuta, and Morgan Kristen, circuit judges. Opinion by Judge Ikuta, dissent by Judge Kristen. Okay. Opinion by Judge, Summary, Civil Rights, First Amendment. The panel reversed the district court's dismissal of a complaint challenging as an unconstitutional restriction of protected speech, Section 165.5401C of the Oregon Revised Code, which generally prohibits unannounced recordings of conversations subject to several exceptions. Section 165.5401C of the Oregon Revised Statutes provides that a person may not obtain the whole or any part of a conversation by means of any device if not all participants in the conversation are specifically informed that their conversation is being obtained. The law provides two exceptions relevant to this appeal. One, Section 165.540 does not apply to a person who records a conversation during a felony that endangers human life. Oregon Revised Statute 165.540A, it's a 5A, and 2, Section 165.5401C allows a person to record a conversation in which a law enforcement officer is a participant of the recording if the recording is made while the officer is performing official duties and meets other criteria. Plaintiff Project Veritas, a nonprofit media organization that engages in undercover investigative journalism, states that it documents matters of public concern by making unannounced audiovisual recordings of conversations, often in places open to the public. Applying Animal Legal Defense Fund versus Wasden, WASDEN, let's see, 878 F3D 1184, 9th Circuit 2018, the panel held that the Section 165.5401C regulates protected speech, unannounced audiovisual recordings, and is content-based because it distinguishes between particular topics by restricting some subject matters, e.g., a state executive officer's official activities and not others, e.g., a police officer's official activities. As a content-based restriction, the rule fails strict scrutiny review because the law is not narrowly tailored to achieving a compelling government interest in protecting conversational privacy with respect to each activity within the prescription scope, which necessarily includes its regulation of protected speech in places open to the public. Thus, citing Cohen versus California, 403 U.S. 1521, 1971, and Hill versus Colorado, 530 U.S. 703, 717, 2000, the panel held that Oregon does not have a compelling interest in protecting individuals' conversational privacy from other individuals' protected speech in places open to the public, even if that protected speech consists of creating audio or visual recordings of other people. The panel further determined that Section 165.5401C burdens more speech than is necessary to achieve its stated interest, and there were other ways for Oregon to achieve its interests of protecting conversational privacy. Finally, addressing the dissent, the panel determined that severing the exceptions that made the general prohibition content-based and extending the general prohibition to those protected First Amendment activities would create significant constitutional issues rather than cure them. Because Section 165.5401C is not a valid time, place, or manner restriction, it cannot be saved by striking the two exceptions at issue here. Dissenting Judge Kristen stated that because the majority does not dispute that the state had a significant interest in protecting the privacy of Oregonians who engage in conversations without notice that their comments are being recorded, the court's analysis should be straightforward. First, principles of federalism require that the panel begin from a premise of reluctance to strike down the state statute. Next, following Supreme Court precedent, the panel should sever the two statutory exceptions that Project Veritas challenges, apply intermediate scrutiny to the content-neutral remainder, recognize that the statute is well-tailored to meet Oregon's significant interest, and uphold Section 165, 540, 1C as a reasonable time, place, or manner restriction. Judge Kristen stated that the purpose Oregon advances is its significant interest in protecting participants from having their oral conversations recorded without their knowledge. The majority recasts the state's interest as one in protecting people's conversational privacy from the speech of other individuals. That reframing of the legislature's purpose serves as the springboard for the majority's reliance on an inapplicable line of Supreme Court authority that pertains to state action aimed at protecting people from unwanted commercial or political speech, not protection from speech gathering activities like Project Veritas's, which are qualitatively different because they appropriate the speech of others. Counsel. Benjamin Barr argued Barr, Klein, PLLC, Bull Valley, Illinois, Stephen Klein, Barr and Klein, PLLC, Washington, D.C. for plaintiffs' appellants. Philip M. Thones argued Assistant Attorney General. Michael A. Casper, Senior Assistant Attorney General. Benjamin Gutman, Solicitor General. Ellen F. Rosenblum, Attorney General of Oregon, Office of the Oregon Attorney General, Salem, Oregon, for defendants' appellees. Opinion, Ikuta Circuit Judge. Oregon law generally prohibits unannounced recordings of conversations, subject to several exceptions. We conclude that Oregon law is content-based. Content-based restriction that violates the First Amendment right to free speech and is therefore invalid on its face. Section 165.540(1)(c) of the Oregon Revised Statutes provides a person may not obtain or attempt to obtain the whole or any part of a conversation by means of any device, if not all participants in the conversation are specifically informed that their conversation is being obtained. Oregon Revised Statutes 165.540. The statute defines conversation as the transmission between two or more persons of an oral communication which is not a telecommunication or radio communication and includes a communication occurring through a video conferencing program. Oregon Revised Statute 165.535. Because this section explicitly applies to the recording of a video conference and bars individuals from obtaining a conversation by means of any device, it applies to both audio and video recordings of a conversation. Indeed, the Oregon courts have interpreted the statute as applicable to video recordings of conversations and other conduct. See State v. Copeland, 522 P3D 909, 911-12, Oregon Court of Appeals, 2022, applying Section 165.540(1)(c) to the video and audio recording of a shooting taken by the victim on his body camera. Okay, there's a few footnotes. Okay, Oregon is one of the few outliers in enforcing such a broad prohibition on unannounced recordings of conversations. Only 5 states, including Oregon, prohibit individuals from making recordings without providing notice or obtaining the consent of the recording subjects in a place open to the public where the subjects lack a reasonable expectation of privacy. 2, because the statutory text and judicial opinions confirm that Section 165.540 applies to video recordings of conversations, the dissent's assertion that the statute does not sweep in video recordings is incorrect. Dissent at 59. 3, contrary to the dissent's argument that Section 165.540 applies only to oral communications, dissent at 48 and 6, Copeland did not differentiate between the video recording of a heated discussion, 522 P3D at 911, and the video recording of the shooting ID at 912, noting that the state sought to introduce the video and audio recording of the shooting taken by the victim on his body camera. The general rule is subject to numerous exceptions. See Oregon Revised Statute 165.540. There are Two are relevant here. First, Section 165540 does not apply to a person who records a conversation during a felony that endangers human life. 165540 This exception applies even if the recording was initiated before the felony began. Copeland 522 P3D at 912. Second, Section 165540 allows a person to record a conversation in which a law enforcement officer is a participant if the recording is made while the officer is performing official duties and meets other criteria. Oregon Revised Statute 165540. The Oregon courts have not yet interpreted this exception. The statute provides that Section 165. Okay. The statute provides Section 165540 does not apply to subscribers or members of the family who perform the acts prohibited in 165540 in their homes. Oregon Revised Statute 165540 and public officials in charge of and at jails, police premises, and other penal or correctional institutions, or persons who use unconcealed recording devices to intercept oral communications that are part of specific public or semi-public meetings. Regularly scheduled classes or similar educational activities in public or private institutions, or private meetings or conferences, if all participants knew or reasonably should have known that the recording was being made. The exception from Section 165.540 applies only if the recording is made while the officer is performing official duties. The recording is made openly and in plain view of the participants in the conversation. The conversation being recorded is audible to the person by normal unaided hearing. And, let's see, the person recording is in a place where the person lawfully may be. Oregon Revised Statutes 165540. Law enforcement officer is generally defined as a person authorized to enforce criminal laws. The general rule in Section 165540 and the two relevant exceptions to the rule evolved over a lengthy period of time. According to the Oregon Supreme Court, the state legislature first enacted Section 165540 in 1955 to allow the police to record telephone conversations when one party consents to the recording. State v. Lissy, 747 PTD 345 347 49 347 number 3, Oregon 1987. In 1959, the legislature amended Section 165540 to add Section 165540(1)(c), which prohibited tape recording of face-to-face conversations without all participants' consent. I id at 350 and number 4. 20 years later, in 1979, some legislators attempted to amend this provision because the concerns that a person who tape records a public meeting, public speech, or classroom lecture without specifically informing all participants that the discussion is being taped is guilty of a Class C felony. Id at 351, citation omitted. This effort to amend the law failed, see id. But in 1989, legislators succeeded in making an exception to Section 165540 for felonies endangering human life, resulting in Section 165540, Oregon Revised Statute 165540(5A) 1989. According to the legislative history of this amendment, the change was made to enable police officers to use a body wire to record a situation that involves a felony where drugs are involved or human life is endangered without first obtaining a court order. A engrossed HB 2252 65th Assembly Register Session 1, Oregon 1989. See also Oregon HR Staff Measure Summary HB 2252. 65th Assembly Register Session, Oregon 1989. This measure would eliminate the requirement that police officers obtain prior court approval before using a body wire where felony drug offenses or life-endangering felonies are being committed. Hearing on HB 2250, 2251, 2252 before the Subcommittee on Crime and Corrections. The H Communication on the Judiciary, 65th Assembly Register Session, 11th-2, Oregon 1989. Statement of Captain Will Hingston, Oregon State Sheriff's Association, stating that Section 165540 causes a great deal of concern for officer safety and informant safety during a narcotics transaction because there is little consistency in obtaining a court order for a body wire before a transaction goes down. And the amendment will afford officers in their performances a great deal more safety and rapid support when doing a narcotics transaction. In 2015, the legislature added another exception to Section Do I really have to just say? I'm live reading my court case. The chirps of the cell phone are letting me know you are still texting. I will take about an hour. Sorry. In 2015, the legislature added another exception to Section 165.5401C to allow a person to record a conversation in which a law enforcement officer is participant, resulting in Section 165.5405B, Oregon Revised Statute 165.5405B 2015. According to testimony by the ACLU submitted to the State Judiciary Committee in support of this amendment, the change was necessary because otherwise the statute was inconsistent with the vast and developing consensus among courts and legal scholars confirming the right to record on-duty police is constitutionally protected. Hearing on HB 2704 before the House Committee on the Judiciary 78th Assembly Register Session 1, Oregon 2015, testimony of Kimberly McCullough, ACLU legal director. The ACLU further testified that because it is common knowledge that the public has a right to record on-duty police, people all over Oregon are unintentionally violating Oregon's eavesdropping statute when they openly record without a warning. Hearing on HB 2704A before the S Committee on the Judiciary 78th Assembly Register Session 1, Oregon 2015. Testimony of Kimberly McCullough, ACLU legal director. Project Veritas is a nonprofit media organization that engages in undercover investigative journalism. Project Veritas stated that it documents matters of public concern by making unannounced audiovisual recordings of conversations, often in places open to the public. In the past, Project Veritas journalists have used undercover recordings to document the Unite the Right rally in Charlottesville, Virginia, to record campaign workers for presidential candidates, to capture the efforts of campaign staff to stir up violence at rallies of the opposing candidate, and to interview the staff for a gubernatorial candidate who confirmed the candidate's more controversial views and efforts to conceal them. Project Veritas stated that it would conduct similar investigations in Oregon, but for Oregon's prohibition on unannounced in-person audiovisual recordings. Among other things, Project Veritas alleged it would investigate corruption at the state agency responsible for enforcing Oregon's public records law by recording undercover interviews with officers and staff in locations open to the public like restaurants, parks, and sidewalks. In addition, Project Veritas alleged it would investigate the rise in violent protests in Portland between the police and members of Antifa and other groups by secretly recording interactions between police officers and protesters. Project Veritas would also send undercover journalists into groups of police and protesters to engage them in conversation and record their candid remarks. Outside of organized rallies, Project Veritas would do most of its undercover recording on public sidewalks, public parks, or in other areas held open to the public. Project Veritas alleged that the safety and even lives of its journalists would be endangered if they were to record conversations openly in plain view or to inform participants that they are being recorded. Project Veritas sued the Oregon Attorney General, Ellen Rosenblum, and the District Attorney of Multnomah County, Oregon, Michael Schmidt, collectively, Oregon, challenging Section 165.540 as an unconstitutional restriction of protected speech. Project Veritas's complaint alleged that because Section 165.540 favored recording some subjects but disfavored others, the differential treatment rendered Section 165.5401C and its exceptions unconstitutional. For instance, the complaint alleged that under Oregon law, an individual could record the police in particular circumstances, see Oregon Revised Statute 165.5405B, and make a secret audio recording during a felony that endangers human life, see it 165.540, but may not openly record the conversations of city council members, school board members, or any other government actors without specifically notifying them, say at 165.5405B. Project Veritas sought to enjoin defendants from enforcing Section 165.540 and to obtain a declaratory judgment that the law is unconstitutional on its face and as applied to Project Veritas. Oregon moved to dismiss the complaint. The district court partially granted the motion, and the parties agreed to dismiss the remaining claims with prejudice. Project Veritas timely appealed. We review de novo a district court's dismissal of a complaint for failure to state a claim. See in re Cuteris sec litig 610 F 3D 1103, 1107, Ninth Circuit 2010, we have an independent obligation to ensure that we have subject matter jurisdiction, which includes a determination that Project Veritas has standing to bring its pre-enforcement claim. Airline Service Providers Association versus LA World Airports, 873, F3D 1074, 1078, Ninth Circuit 2017. Project Veritas's allegations are sufficient to establish standing for the First Amendment pre-enforcement claim. Under Article 3 of the Constitution, plaintiffs must establish the irreducible constitutional minimum of standing by showing that they have suffered an injury in fact, that there is a causal connection between the injury and the conduct complained of, and that it is likely that the injury will be redressed by a favorable decision. Lujan versus Deaths of Wildlife. Defense of Wildlife. Okay, 503 U.S. 555, 560 to 61, 1992. Citations and quotation marks omitted. Because constitutional challenges based on the First Amendment present unique standing considerations, plaintiffs may establish an injury in fact without first suffering a direct injury from the challenged restriction. Lopez v. Candale, 630 FD 3D 775, 785, 9th Circuit 2010, cleaned up. In a pre-enforcement, let's see. Okay, this is a footnote 6. Project Veritas's complaint challenge sections 165.5401C, making unannounced recordings, 165.5401D, obtaining such recordings from others, and 165.5401E, distributing such recordings is E. Okay. The district court denied Oregon's motion to dismiss with respect to Project Veritas's section 165.5401D and 1E claims, but the parties later agreed to dismiss those claims with prejudice. Okay, so here we are. In a pre-enforcement challenge, plaintiffs can show injury in fact by establishing that they intend to violate the law and have shown a reasonable likelihood that the government will enforce the statute against them. Wow, they intend to violate the law and have shown a reasonable likelihood that the government will enforce the statute against them. For purposes of this pre-enforcement challenge, Project Veritas makes a clear showing of injury in fact. First, Project Veritas alleged that, but for Section 165.5401C, it would make unannounced recordings of conversation in a manner that would violate the general prohibition and not fall within an exception, and described in great detail the person's conversations and events it would like to record. See Super Part page 10 through 11. For its part, Oregon has prosecuted individuals for violating 165.5401C in the past and does not state that it would refrain from prosecuting Project Veritas for creating such recordings if the recordings were made in violation of the law. Finally, Project Veritas alleged a causal connection between the challenged statute and its inability to carry on its undercover journalistic endeavors, and that it is likely that its injury will be redressed by a favorable decision. Footnote 8, because we conclude that Section 165.5401C is facially unconstitutional, we do not evaluate Project Veritas's alternative challenge that the statute is overbroad. Okay, I get it. So this is citations to State v. Bishel, State v. Noble, State v. Neff, State v. Depeche. Okay, we reject Oregon's arguments that we lack jurisdiction because Project Veritas asserts an as-applied challenge, which is not ripe. Project Veritas's claim is properly construed as a facial challenge to Section 165.540. A facial challenge is an attack on a statute itself as opposed to a particular application. City of Los Angeles v. Patel, 576 U.S. 409, 415, 2015. While an as-applied challenge contends that the law is unconstitutional as applied to the litigant's particular speech activity, even though the law may be capable of valid applications to others, Foti v. City of Menlo Park, 146, F3D 629, 635, 9th Circuit, 1998. Here, Project Veritas attacks the statute itself as an unconstitutional regulation of unannounced recordings of nearly all conversations held in places open to the public, not only those conversations that Project Veritas seeks to record. The First Amendment, applicable to the states through the 14th Amendment, provides that Congress shall make no law abridging the freedom of speech. U.S. Constitution Amendment 1. While the First Amendment literally forbids the abridgment only of speech, the Supreme Court has long recognized that its protection does not end at the spoken or written word. United States v. Swisher, 811 F3D 299 310, Ninth Circuit 2016, cleaned up citation and quotation marks omitted. We have recognized there is no material distinction between the process of creating a form of pure speech, such as writing or painting, and the product of these processes, the essay or artwork, in terms of the First Amendment protection afforded. Anderson versus City of Hermosa Beach, 621 F3D 1051 1061 Ninth Circuit 2010. Indeed, we have never seriously questioned that the process of writing words down on a paper, painting a picture, and playing an instrument are purely expressive activities entitled to a full First Amendment protection. It at 1062. Okay, the footnote 9, but we must analyze section 165.5401C with respect to the full scope of its prohibition. It is relevant that Project Veritas seeks to record only in public places, or avers only that most of its recording will occur in public places. Dissent at 49. We're at page 15 here. Here, the state law at issue regulates individuals' conduct in making an audio or visual recording. Under our case law, such conduct qualifies as speech entitled to the protection of the First Amendment. See Animal Legal Defense Fund versus Wasden, 878 F3D 1184, 1203.204, 9th Circuit 2018. Wasden involved a secretly filmed expose of the operation of an Idaho dairy farm, which showed dairy workers who dragged a cow across the ground by a chain attached to her neck, twisted cows' tails to inflict excruciating pain, and repeatedly beat, kicked, and jumped on cows to force them to move. It at 1189. This 2012 expose, distributed by an animal rights group, Mercy for Animals, resulted in the Idaho legislature enacting a statute targeting undercover investigation of agriculture operations, which criminalized, among other things, a person from entering a private agricultural production facility and, without express consent from the facility owner, making audio or visual recordings of a conduct of an agricultural production facility's operations. It at 1203, citation omitted. The statute defined its scope broadly and did not exclude audio or video recordings of conversations. See it. In enacting the law, members of the Idaho legislature discussed the bill as protecting against two types of perceived harm to agricultural producers, specifically concerns about farm security and privacy, and concerns about damage caused by the investigative reporting itself. One legislator described the videos as used publicly to crucify a company and as a blackmail tool. After noting the tension between journalists' claimed First Amendment right to engage in undercover investigations and the state's effort to protect privacy and property rights, it at 1190, we held that the animal rights activists' conduct creating an unannounced recording was constitutionally protected First Amendment speech. It at 1203 to 204. Wasden reached this conclusion in two steps. First, Wasden extended our prior ruling that there is a First Amendment right to film matters of public interest. ID at 1203, emphasis added, citing Fordice, I'm saying Fordyce versus City of Seattle, 55 F3D 436 439, 9th Circuit 1995, to hold that the act of recording is itself an inherently expressive activity protected by the First Amendment. ID emphasis added, we reasoned that audio and visual recordings require decisions about content, composition, and the like, which decisions are just as expressive as the written word or a musical score, ultimately disseminated to the public. ID, because the recording process is itself expressive and is inextricably intertwined with the resulting recording. The creation of audiovisual recordings is speech entitled to First Amendment protection as purely expressive activity. 1204, citation omitted. Second, given that the act of recording is protected speech, Wasden held that the statute's prohibition of recording the conduct of an agricultural production facility's operations without express consent from the facility owner constituted A regulation of a form of protected speech which triggered First Amendment scrutiny. ID, is it it or ID? 1203-04. Applying Wasden's conclusion here, Section 165.5401C prohibits making audio and visual recordings unless all participants in the conversation are informed of the recording. Under Wasden, the recording itself is protected speech, and therefore the Oregon statute constitutes a regulation of protected speech. We conclude that Section 165.5401C triggers First Amendment scrutiny. B, because we must determine the constitutionality of Section 165.5401C under the First Amendment, we next turn to the question whether it is content-based or content-neutral. See Reed versus Town of Gilbert, 76 U.S. 155163, 2015. A law is content-based if it singles out any topic or subject matter for differential treatment. City of Austin versus Reagan, National AD of Austin, LLC, 142, S. Court, 1464, 1472, 2022. Footnote 10. Wasden's conclusion is consistent with our sister circuits, which have held that creation of audio and video recordings constitutes First Amendment protected speech. See, for example, e.g., People for the Ethical Treatment of Animals, Inc. versus North Carolina Farm Bureau Federation, Incorporated, 60 F. 4th, 815, 821 to 23, 4th Circuit, 2023, rejecting argument that the creation of unauthorized recordings of images or sound occurring within an employer's premises as part of undercover investigations conducted by PETA to publicize animal cruelty was not speech protected by the First Amendment. MCL Union of Illinois versus Alvarez, 679 F3D 583 595, Circuit 2012. The act of making an audio or visual recording is necessarily included within the First Amendment's guarantee of speech and press rights. Smith versus City of Cumming, 212 F3D 1332 1333, 11th Circuit 2000, holding that the First Amendment protects the right to record matters of public interest. Wasden again guides our analysis. After holding that the creation of audio and video recordings was speech entitled to full First Amendment protection, Wasden held that the Idaho statute at issue in that case, which required the facility owner's consent to make unannounced recordings of the conduct of an agricultural productions facilities operation, was an obvious example of a content-based regulation of speech because it defines regulated speech by particular subject matter. 878 F3D at 1204, citing Reed 5676 US at 163. We gave two reasons for this conclusion. First, the statute drew a distinction on its face regarding the message the speaker conveys, citing Reed 576 US at 165. Specifically, it would permit filming a vineyard's art collection, but not the winemaking operation. Likewise, a videographer could record an after-hours birthday party among coworkers, a farmer's antique car collection, or a historic maple tree, but not the animal abuse, feedlot operation, or slaughterhouse conditions. And second, we recognize that only by reviewing the recording can the state authorities make a determination about criminal liability, because the application of the exception explicitly pivots on the content of the recording. Our second rationale, that a law regulating the act of making specified recordings is content-based if state authorities cannot apply the law without reviewing or listening to the particular recording at issue, requires some further examination. After we decided Wasden, the Supreme Court rejected a per se rule that a regulation cannot be content-neutral if it requires reading the speech at issue. City of Austin 142 S Court at 1471. Instead, City of Austin held that location-based rules, such as a rule differentiating between signs on a premises that advertise an on-site business from signs that advertise some off-site matter, are not content-based, even though city authorities had to review the sign's message to apply the rule. At 1472, when a rule is merely a location-based and content-agnostic on-off premises distinction, it does not single out specific subject matter for differential treatment. It at 1475, citations omitted. Indeed, the sign's message merely informs the sign's relative location. It at 1473. But as the court clarified, this exception for location-based rules does not affect the court's longstanding holding that regulations that discriminate based on the topic discussed or the idea or message expressed are content-based. It at 1474, citation and quotation marks omitted. Weston did not address a location-based rule akin to an on-off premises distinction, but considered a rule that singled out specific subject matter for differential treatment and discriminated based on the topic discussed or the idea or message expressed. It at 1474 to 75. As a result, City of Austin's analysis does not conflict with our holding in Wasden, which remains binding. See Miller v. GAMI 335 F3D 889 893 9th Circuit 2003, holding that a three-judge panel is bound by precedent unless it is clearly irreconcilable with the reasoning or theory of intervening higher authority. Therefore, we continue to consider whether a law pivots on the content of the recording. Wasden 876 F3D at 1204 in determining whether the law discriminates on the basis of the topic discussed or the idea or message expressed, and is therefore content-based. City of Austin 142 S Court at 1474, citing Reed 576 U.S. at 171. Applying Wasden here, Section 165.540 is a content-based restriction on speech. On its face, Section 165.5401C and its exceptions draw a distinction between topics. The speech regulated by Section 165.5401C is the act of making a recording, which means that the activity captured by the recording constitutes the content or subject matter of that speech. Because the rules imposed by Section 165.540 vary depending on the activity being recorded, the statute clearly draws content-based distinctions under Wasden. The law's applicability plainly pivots on the content of the recording, namely what the recording captures. Wasden 878 F3D at 1204. For example, the law applies no restrictions to recording law enforcement officials engaged in their official duties. See Oregon Revised Statute 165.5405B, but prohibits recording other government officials performing official duties unless they are informed that their conversation is being recorded. Similarly, the statute distinguishes between recording felonies endangering human lives, 165.5405A, and recording similar conduct during the commission of a misdemeanor. These distinctions are obvious examples of a content-based regulation of speech because they define regulated speech by particular subject matter. Wasden 878 F3D at 1204, cleaned up, citation omitted. In addition, state authorities can make a determination about criminal liability under the law only by viewing the recording ID. This serves as further evidence that applicability of Section 165.5401C pivots on the content of the recording, thereby demonstrating that the law is content-based. Oregon argues that Section 165.5401C's general prohibition on the act of making unannounced recordings is content-neutral speech regulation for two reasons. Neither is persuasive. Oregon first argues that the statute is content-neutral because the statute's exceptions are not based in the words spoken and recorded, and therefore state authorities do not have to listen to and analyze the recording to determine whether an exception applies. We disagree. The statute at issue in Wasden did not distinguish based on the words spoken in the recording, but we nevertheless held that it was content-based because it discriminated on the base of subject matter to be recorded, 878 F3D at 1204. For the same reason, it is the statute's differential treatment of recordings based on their subject matter, e.g. whether the speaker's recording obtains the conversation of Oregon police officers or Oregon executive officers, that makes the statute content-based, not the words exchanged in the conversation. Second, Oregon argues that we can consider Section 165.5401C as a standalone provision and ignore the exceptions to the general prohibition. But this approach is foreclosed by binding precedent. To start, it is well established that when a court evaluates the constitutionality of a general prohibition, it must consider any exceptions to the general rule. A rule is content-based when it establishes a general ban on speech, but maintains exceptions for speech on certain subjects. Glendale Associations Limited versus NLRB 347 F3D 1145 1155 9th Circuit 2003. Stated differently, where exceptions to a restriction of protected speech are based on content, the restriction itself is based on content. National Aid ADCO versus City of Orange 861 F2D 246-249, 9th Circuit 1988, citation omitted. See also Barr versus American Association of Political Consultants, Incorporated 140 S Court 2335-2347, 2020 plurality opinion, holding that a prohibition of robocalls was content-based due to its exception for robocalls collecting government-held debts. FOTI 146 F3D at 636, holding that an ordinance's general ban of all signs on all public property was content-based due to its exemptions for open house signs and safety traffic and public information signs. Moreover, any exception to a general restriction on protected speech, even if the exception applies to speech that our case law has recognized as receiving First Amendment protection, like recording police officers performing official duties in public, see Fortiche 55 F3D at 439 Askins versus United States Department of Homeland Security 899 F3D 35 1044 Ninth Circuit 2018 necessarily renders the restriction content-based. The Supreme Court analyzed a similar situation in Reed, where the challenged state law generally restricted the display of outdoor signs without a permit, but exempted signs that had ideological and political messages, which implicate speech that case law has recognized as receiving First Amendment protection. 576 U.S. at 164 to 65. Despite these exceptions, the court held that the law as a whole was content-based and subject to strict scrutiny. Regardless of the government's benign motive, content-neutral justification or lack of animus towards the ideas contained in the regulated speech. Let's see. Okay. So I'm going to read the footnote 11. The district court concluded that the law enforcement exception did not render section 165.540(1)c content-based because recordings of conversations where law enforcement officer is a speaker is government speech, which is generally not subject to First Amendment challenges. Oregon does not rely on this argument, and we conclude the government speech doctrine is not applicable here. Although the Supreme Court has held that a government entity's expression of its own views does not violate the speech rights of individuals who disagree, see Pleasant Grove City versus Summum, 555 U.S. 460, 467, 2009. This case does not involve a suit against the government for expressing its views. Rather, it involves a statute that impinges on a private individual's speech by restricting the ability to record public officials. The individual engaging in the speech being regulated is the private party that makes the recording, not the government. Therefore, the government speech doctrine is inapposite. Okay. Oh, okay. Where were we? Ooh. We were about page 20. Okay. It's contained in the regulated speech at 165 citation omitted. Therefore, under the precedent, we must analyze both the general prohibition and the exceptions as one regulatory regime. Doing so makes clear that section 165.540 is a content-based regulation of speech. Because we conclude that section 165.540(1)c and its exceptions constitute a content-based speech scrutiny restriction, we can uphold the statute only if it survives strict scrutiny. See Wasden 878 F3D at 1204. Strict scrutiny requires the government to show that the speech restriction is narrowly tailored to address the state's compelling governmental interests. Victory Processing LLC versus Fox 937 F3D 1218 1229 9th Circuit 2019. Under strict scrutiny, the challenged law must be constitutional with respect to each activity within the prescription scope. Berger versus City of Seattle 569 F3D 1029 1053 9th Circuit 2009, citing Frisbee versus Schultz 487 U.S. 474 485 1988. It does not matter that a narrow restriction on speech activities could have been justified by the government's interests. See Watchtower Bible versus and Tract Society of New York Inc. versus Village of Stratton, 536 U.S. 150 168 2002. For instance, a law that generally prohibits canvassers from engaging in door-to-door advocacy without a permit is facially unconstitutional. Although the government's interest in preventing fraud could adequately support the ordinance insofar as it applies to commercial transactions, and the solicitation of funds, the interest in fraud protection does not justify the ordinance insofar as the dissent concedes that the statutory exemptions to the general ban on unannounced recordings render section 165.540 content-based. Dissent at 50. Okay. We're on page 24. Applies to Jehovah's Witnesses who offer religious literature to political campaigns or to enlisting support for unpopular causes. In Wasden, we applied strict scrutiny to the content-based Idaho statute, 878 F3D at 1204. We assume that Idaho's asserted interest in protecting both property and privacy interests in an agricultural production facility was a compelling government interest, see it, but concluded that Idaho had not satisfied the narrow tailoring requirements because, among other reasons, there were various other laws at Idaho's disposal that would allow it to achieve its stated interests while burdening little or no speech. It at 1205. Cleaned up citation and quotation marks omitted. For example, agricultural production facility owners can vindicate their rights through tort laws against the theft of trade secrets and invasion of privacy. As another example, to the extent of legislators expressed concern that fabricated recordings of animal abuse would invade privacy rights, the victims can turn to defamation actions for recourse. Further, we explained the remedy for speech that is false is speech that is true, and not, as Idaho would like, the suppression of that speech. Cleaned up, citation omitted. Therefore, we struck down Idaho's ban on creating audio and visual recordings as failing to survive First Amendment scrutiny. Applying strict scrutiny to section 165.540(1)(c) in light of these precedents, we must consider whether that section is constitutional with respect to each activity within the prescription scope, Berger 569 F3D at 1053, which necessarily includes its regulation of protected speech in places open to the public. See Supra V 14 and 923 to 24. We first consider the nature of Oregon's interest here. At the outset, Oregon does not assert it has a compelling interest, but argues only that it has a significant government interest in protecting individuals' conversational privacy. In analyzing this interest, we are bound by Wasden's conclusions that the act of recording is itself an inherently expressive activity that merits First Amendment protection. 878 F3D at 1203. Therefore, prohibiting a speaker's creation of unannounced recordings in public places to protect the privacy of people engaged in conversation in those places is the equivalent of prohibiting protesters or busker speeches in public places for the same purpose. See Berger 569 F3D at 1054. Thus, we must analyze Oregon's interest in conversational privacy as protecting people's conversational privacy from the speech of other individuals, even in places open to the public. In general, the government does not have a compelling interest in protecting individual privacy against unwanted communications, including the speech comprised of recording others, in areas open to the public, unless the audience's substantial privacy interests are being invaded in an essentially intolerable manner. Cohen v. California, 403 U.S. 1521, 1971. Also Hill v. Colorado, 530 U.S. 703, 717, 2000. Recognizing that the government's interest in protecting privacy varies widely in different settings, courts have recognized such a compelling interest only when patients seeking medical care are bombarded by the cacophony of political protests and individuals at their homes are confronted with unwanted speech. Hill, 530 U.S. at 716. The government's interest in protecting the public's privacy from unwanted speech, including recordings of people's conversations, is far less important for individuals engaging in recreational, social, or commercial activities in places open to the public, such as strolling through Central Park, or waiting in line, or having lunch outdoors in a public park. Berger 569 F3D at 1054. Indeed, we have held that the government does not even have a significant interest in protecting individuals from unpopular speech, where those who constitute the intended audience are commercial patrons of a place of public entertainment. Cuba v. 1A Agricultural Association 387 F3D 85861 number 10, 9th Circuit 2004. Applying this framework here, Oregon does not have a compelling interest in protecting individuals' conversational privacy from other individuals' protected speech in places open to the public, even if that protected speech consists of creating audio or visual recordings of other people. Nor is Oregon's rule narrowly tailored to be the least restrictive or least intrusive means of achieving the government's interest in conversational privacy, as required to pass strict scrutiny review. Ward v. Rock against Racism, 491, U.S. 781, 798 to 99, and number 6, 1989. Under strict scrutiny, a speech restriction must target and eliminate no more than the exact source of the evil it seeks to remedy. Frisbee, 487, U.S. at 485, citation omitted. A law is not narrowly tailored if it restricts speech that does not cause the types of problems that motivated the law. Committee de Jornaleros de Redondo Beach versus City of Redondo Beach, 657 F3D 936 948 9th Circuit 2011 en banc. In addition, a law is not narrowly tailored if it is over-inclusive because it suppresses more speech than is necessary to further Oregon's goal of protecting people's conversational privacy. See Wasden, 878 F3D at 1205. Page 27. Applying this test, we conclude that Section 165.540 burdens more protected speech than is necessary to achieve its stated interests. See, the law regulates protected speech to avoid impinging on people's conversational privacy. But in public places, speech does not intrude on privacy unless it intrudes in an essentially intolerable manner. See Berger, 569 F3D at 1056, holding a statute prohibiting passive and unthreatening acts, such as offering a handbill or displaying a sign, even if the communications were unwanted, was not narrowly tailored under intermediate scrutiny. As the Supreme Court has explained, it is difficult indeed to justify a prohibition on all uninvited approaches, regardless of how peaceful the contact might be, without burdening more speech than necessary to prevent intimidation. Madsen versus Women's Health Center Incorporated, 512 U.S. 753774, 1994. Section 165.5401C does not distinguish between passive and unthreatening acts and intolerable intrusions. Under case law, that does not constitute narrow tailoring. Moreover, where speech occurs in places open to the public, the privacy interest of other individuals in those public areas is implicated only if and where the speech is unwanted. C. Hill, 530 U.S. at 716, Berger, 569 F3D at 1056. Yet Section 165.5401C does not distinguish between wanted and unwanted speech, including wanted or unwanted recordings. For example, protesters demonstrating in favor of their political views may have no objection to unannounced recordings of conversations, which would provide more publicity about their goals and beliefs. For its part, the dissent apparently assumes without explanation that all unannounced recordings are unwanted speech and all announced recordings are welcome speech. While some people may desire privacy for a conversation held in places open to the public, such instances cannot justify Oregon's wholesale restriction on protected speech, i.e. recordings in public areas. See Rock against Racism, 491 U.S. at 799, stating that a speech restriction may not regulate expression in such a manner that a substantial portion of the burden on speech does not serve to advance its goals. The dissent argues that Berger and his progeny are inapplicable to Section 165.5401C because state action aimed at protecting people from unwanted commercial or political speech is qualitatively different than state action protecting people from speech-gathering activities like Project Veritas's because they appropriate the speech of others. Dissent at 45. According to this dissent, the sort of speech that includes the appropriation of another person's speech, i.e. recordings, is qualitatively more burdensome than other types of speech that might intrude on a person's privacy. Dissent at 64. The position is foreclosed by Wasden, which does not accord any special attention to the privacy interests of people whose speech might be recorded. Rather, Wasden held that a state law prohibiting audio or video recordings of the conduct of an agricultural production's facilities operations, which necessarily would include conversations, directions, and other forms of oral communications, suppressed more speech than necessary to further Idaho's stated goals of protecting property and privacy. 878 F. 3D at 1205, Wasden's analysis of recordings under the same framework applicable to other sorts of protected speech is consistent with precedent. For example, under our case law, we analyze expressive conduct that merits First Amendment protection as symbolic speech in the same manner as we analyze oral communications. See Swisher 811, F3D at 318. Content-based prohibitions of speech and symbolic speech are analyzed under the same framework. Finally, as in Wasden, the rule is not narrowly tailored because there are various other laws at Oregon's disposal that would allow it to achieve its stated interests while burdening little or no speech. 878 F3D at 1205, citation and quotation marks submitted, individuals whose conversation is captured in public by unannounced recordings can vindicate their rights through an invasion of privacy tort. CEG Humphreys versus First Interstate Bank of Oregon. 696 P2D 527 531 to 32, Oregon, 1985, en banc, noting that Oregon has recognized the common law privacy torts of appropriation, offensive publication of private facts, and intrusion upon exclusion. State versus Lien, 441 P30D 185 193, Oregon, 2019. Tortious invasion of privacy is one of the limited number of torts in Oregon in which a plaintiff may be awarded damages consisted solely of mental suffering caused by the violation. Anderson versus Fisher Broad, cause 712 P2D 803-814, Oregon, 1986, explaining instances where a television program airing photographs of an accident victim could give rise to a tortious invasion of privacy claim. The dissent's reliance on the this is footnote 14, the dissent's reliance on the Hurley versus Irish American Gay, Lesbian, and Bisexual Group of Boston, 515 U.S. 557, 1995, for the argument that speech involving the creation of a recording that captures people's speech implicates the principle of autonomy to control one's own speech is misplaced. The dissent in 57 to 58, Hurley held that the First Amendment prohibits the state from forcing a speaker to incorporate a message the speaker does not want to convey. See it at 559, 581. To the extent Hurley has any bearing on this case, it supports our view that a law raises serious constitutional issues if it prohibits the speaker from conveying the message the speaker wants to convey, candid responses to candid issues of controversy by making unannounced recordings. McLean versus Boise Cascade Corp. 533 P2D 343 345 to 46, Oregon, 1975, holding that unannounced recordings of the plaintiff engaged in various activities on his property outside his home were not actionable as invasion of privacy torts because the recordings were done in such an unobtrusive manner. The plaintiff was not aware that he was being watched or filmed, and the plaintiff could have been observed by a passerby. Or if the recording is fabricated, the victims can turn to defamation actions for recourse. Wasden 878 F3D at 1205. See also Neumann versus Lyles, 369 P3D 11117 111 1120 to 21, Oregon, 2016. We conclude that Section 165.5401C regulates protected speech, unannounced audiovisual recording, and is content-based because it distinguishes between particular topics by restricting some subject matters, e.g. a state executive officer's official activities, and not others, e.g. a police officer's official activities. As a content-based restriction, the rule fails strict scrutiny review because the law is not narrowly tailored to achieving a compelling government interest in protecting conversational privacy with respect to each activity within the prescription scope. Berger 569 F3D at 1053, and there are other ways. Okay, other ways for Oregon to achieve its interests. See Wasden 878 F3D at 1205, footnote for page 30. The dissent's concern regarding deepfakes is overblown. Dissent in 56 to 57, 72 North, and 16, as we explained in Wasden, victims of such fabrications can vindicate their rights through tort actions. C878 F3D at 1205. Moreover, deepfakes are not a problem unique to unannounced recordings. Such deepfakes can be created just as easily with unannounced recordings with announced recordings. As the dissent states, all one needs is audio and video of the person to be modeled to create a deepfake. Dissent at 56 to 57, 72 to number 16. Okay, so we're on to 4, page 31. The dissent agrees with our holding that Section 165.5401C and its exceptions constitute a content-based speech restriction that fails strict scrutiny review. Dissent at 5063. This should end our analysis. Instead, the dissent argues that Section 165.541C's general prohibition should be analyzed as a standalone provision that by itself is a constitutional content-neutral speech restriction. Dissent at 53 to 54. To reach a conclusion, the dissent relies exclusively on its argument that the court should offer Oregon a remedy of severability. Dissent at 50-53. Oregon chose not to make this argument to the district court or to our court, but we briefly address it here. CF Comité de Généraux de Redondo Beach, 657 F3D at 951, number 10, declining to sever a subsection of a challenged statute because the city had forfeited any argument regarding severability by failing to raise it in its briefs or at oral argument. Severability is, of course, a matter of state law. Leavitt versus Jane L., 518 U.S. 137, 139, 1996. To determine whether a state statute is severable, we are bound by state statutes and states' court opinions. See San Francisco Found versus Christie's Incorporated, 784 F3D 1320, 1325, 9th Circuit, 2015 en banc. The dissent cites several Supreme Court cases decided before we issued Comité de Généraux, dissent at 51 to 52, 52 number 7, but we are bound by our precedent unless it is irreconcilable with a subsequent higher authority. See Miller 335 F3D at 893. The Oregon Supreme Court addressed the nature of severability in State v. Dilts, 103 P3D 9599, Oregon 2004 en banc. According to the Oregon Supreme Court, the relevant statute, section 174.040, governs decisions regarding severability. The statute provides that it is the legislative intent in the enactment of any statute that if any part of the statute is held unconstitutional, the remaining part shall remain in force unless an exemption applies. The exemptions to the presumption that the legislature would prefer an unconstitutional part of a statute to be severed and the rest to remain in force include circumstances where parts of the statute are so interconnected that it appears likely that the remaining parts would not have been enacted without the unconstitutional part, or if the remaining parts are incomplete and cannot be executed in accordance with legislative intent. Outdoor. 17. Dilts provided a generally applicable analysis of Oregon severability law. Nothing in the opinion suggests that this analysis would be different if a party proposed severing the unconstitutional portion of a civil statute rather than a criminal statute. But see dissent at 65. Section 174.040 of Oregon Revised Statutes provides in full, it shall be considered that it is legislative intent in the enactment of any statute that if any part of the statute is held unconstitutional, the remaining part shall remain in force unless the statute provides otherwise. The remaining parts are so essentially and inseparably connected with and dependent upon the unconstitutional part that it is apparent that the remaining parts would not have been enacted without the unconstitutional part, or the remaining parts standing alone are incomplete and incapable of being executed in accordance with the legislative intent. Okay, so where were we? The remaining parts are incomplete. Outdoor Media Dimensions Incorporated versus Department of Transportation, 132 P3D 518, Oregon 2006. Based on this statute, the Oregon Supreme Court cases severability analysis applies when part of a statute is held to be unconstitutional. Dilts 103 P3D at 99. Under such circumstances, a court must consider whether that part of the statute can be severed and the remaining parts of the statute saved. Namely, under this framework, a court must make two determinations. First, it must conclude that the part of the statute is unconstitutional. Second, it must conclude that the rest of the statute can be saved, meaning it would be deemed constitutional if the unconstitutional part were severed. When a party contends that the entire act is unconstitutional, then severability is not germane until the constitutional claim is resolved. Bernstein Bros versus Department of Revenue, 661 P2D 537 539, Oregon 1983. As a general rule, under Dilts in section 174.040, a court's threshold determination is whether a part of the statute is unconstitutional. Indeed, Dilts rejected Oregon's severability argument in that case because no party alleged that the specific provision in the state proposed to sever was unconstitutional. 103 P3D at 99. Nevertheless, when a statute raises First Amendment concerns because it is content-based, the Oregon Supreme Court has considered whether to sever a portion of this statute that singles out a topic or subject matter for differential treatment, even if that portion is not itself unconstitutional. See Outdoor Media Dimensions Incorporated, 132 P3D at 19. In this context, Outdoor Media Dimensions considered a state statute that required a permit for a sign whose message does not relate to the premises on which the sign is located, while providing an exemption for a sign whose message does relate to the premises on which the sign is located. It at 7. The court first held that by exempting on-premises signs from the permit requirement, the statute was on its face an impermissible restriction on the content of speech in violation of the Oregon Constitution. It at 18. Turning to the issue of severability, the court explained that to remedy the constitutional violation, it could either invalidate the permit requirement or sever the exception for on-premises signs. It at 19. The court determined that faced with the choice, the legislature would have been willing to extend the statute's permit and fee requirements to on-premises signs, and therefore the court held that the appropriate remedy was to invalidate the permit requirement. Under the outdoor media, we may consider whether severing the exceptions to Section 165.5401C could save that section's general prohibition, even though the exceptions are not themselves unconstitutional. Assuming that Section 165.5401C, considered by itself, is content neutral, it can be saved as constitutional if it qualifies as a valid time, place, or manner restriction. Such a restriction must be content neutral, survive intermediate scrutiny review, and 3, leave open ample alternative channels for communication of the information. Hoy versus City of Oakland, 653 F3D 835-844, 9th Circuit, 2011, citing Rock against Racism, 491 U.S. at 791. Also Reagan v. Time, Inc., 468 U.S. 641, 648, 1984. Assuming that Section 165 v. 5401C would be content neutral if it were a standalone provision and would survive intermediate scrutiny review, we conclude it does not satisfy the third requirement. A regulation that forecloses an entire medium of public expression across the landscape of a particular community or setting fails to leave open ample alternatives. United BHD of Carpenters and Joiners, or Brotherhood of Carpenters and Joiners of American Local 586 versus NLRB 540 F3D 957-969, 9th Circuit, 2008. Regulations may not hamper a speaker's preferred mode of communication to such an extent that they compromise or stifle the speaker's message. C. McCullen and Coakley, 573 U.S. 564, 487, 90, 2014. Alternatives that are less effective media for communicating the speaker's message are far from satisfactory. Landmark Associations, Inc. versus Township of Willingboro, 431 U.S. 85 to 93, 1977. Free speech protections extend to the right to choose a particular means or avenue of speech in lieu of other avenues. United Brotherhood, 540 F3D at 969, cleaned up, citation and quotation marks omitted. Thus, while the government may regulate the manner of speech in a content-neutral way, the government may not infringe on an individual's right to select the means of speech. FOTI 14653D at 641 to 42. For example, in City of Ladue versus Gilio, the Supreme Court held that an ordinance that prohibited displaying signs in front of one's residence did not leave open ample alternative channels of communication. 512 U.S. 4356, 1994. In reaching that conclusion, the Supreme Court rejected the city's argument that the law left open ample alternative channels of communication because residents remain free to convey their desired messages by other means, such as handheld signs, letters, handbills, flyers, telephone calls, newspaper advertisements, bumper stickers, speeches, and neighborhood or community meetings. ID, citation and quotation marks omitted. In doing so, the Supreme Court explained that displaying a sign from one's own residence often carries a message quite distinct from placing the same sign someplace else or conveying the same text or picture by another means. Indeed, it is precisely because of their location that such signs provide information about the identity of the speaker. I did quotation marks omitted. To illustrate, the Supreme Court noted that a sign advocating peace in the Gulf in the front lawn of a retired general or a decorated war veteran may provoke a different reaction than the same sign in a 10-year-old child's bedroom window or the same message on a bumper sticker of a passing automobile. Likewise, an espousal of socialism may carry different implications when displayed on the grounds of a stately mansion than when pasted on a factory wall or an ambulatory sandwich board. It at 56 to 57. Moreover, the intention behind placing a sign at one's residence may be to reach neighbors, an audience that could not be reached nearly as well by other means. It at 57, emphasis omitted. In some instances, barring a means of speech effectively eliminates a message. For speakers of modest means or limited mobility, a yard or window sign may have no practical substituted. And for others, the added costs in money or time of taking out a newspaper advertisement, handing out leaflets on the street, or standing in front of one's house with a handheld sign may make the difference between participating and not participating in some public debate. In light of this understanding of what case law requires for a speech restriction to leave open, ample alternative channels for communication, it is clear that Section 165.5401C does not meet the mark. It functions as an absolute prohibition on a particular type of expression, the creation of unannounced audiovisual recordings. United States v. Grace, 461 U.S. 1671177, 1983. Section 165.5401C allows individuals to record conversations where participants are specifically informed that their conversation is being obtained. Such notification would effectively destroy the intended content of the recording. The subject matter of unannounced recordings is the subject's candid responses to issues of controversy. Because the protected speech is the recording of subjects' unfiltered responses, see Wasden 878, F3D at 1204, a rule that requires the person creating the recording to provide notice extinguishes that speech. In other words, creating announced recordings is not an adequate alternative channel of speech for creating unannounced recordings. Nor does after the fact reporting of an undercover interview or encounter provide an adequate alternative method of communication. Audiovisual recording is a unique medium of communication. It captures in real time both the sounds and sights of an event, making it more trustworthy and persuasive, thus having vastly greater impact than post hoc written or oral accounts. See Fields versus City of Philadelphia, 862 F3D 353 359, Third Circuit 2017, noting that audiovisual recordings corroborate or lay aside subjective impressions for objective facts. MCL Union of Illinois versus Alvarez, 679 F3D 583 595 607 7th Circuit 2012, stating that the self-authenticating character of audiovisual recordings makes it highly unlikely that other methods could be considered reasonably adequate substitutes. Indeed, the Supreme Court recognized the importance of audiovisual recording as corroborating or disproving testimony in Scott v. Harris, even on summary. Okay, footnote 19. In fact, the dissent expressly acknowledges these attributes, which are unique to unannounced recordings, dissent of 55. But by recognizing that unannounced recordings are unique, the dissent has necessarily conceded that other forms of media are inadequate substitute. Page 38. So we're going from even on summary. I'm on my script version of Blocker, so it's a bit messy. Okay. Oh boy, where am I? Am I really? Okay, even on summary judgment, when courts are required to view the facts and draw reasonable inferences in the light most favorable to is this really where I am? Concede. Okay, yes. In light of the most favorable to the opposing party, party opposing the summary judgment motion, the court must rely on the record of a videotape capturing the events in question when it clearly contradicts the version of the story told by the non-moving party, 550 U.S. 372, 378, 2007, citation omitted. Audiovisual recordings are also unique because they can readily be disseminated to a wider audience when incorporated into news programming. See Fields 862 F3D at 359. Recordings also facilitate discussion because of the ease of which they can be widely distributed via different forms of media. American CL Union of Illinois, 679 F3D at 607, noting that audiovisual recordings are powerful methods of disseminating news and information. Accordingly, Section 165.5401C does not leave open alternative channels to real-time unannounced audiovisual recordings. And we therefore conclude that Section 165.5401C, if read as a standalone provision without exceptions, is not a valid time, place, or manner restriction. In opposing the analysis and arguing that Section 165.5401C leaves open ample alternative channels of communication, the dissent reframes the medium of public expression sought by Project Veritas at a high level of generality. According to the dissent, the relative medium of communication is not the unannounced recordings that capture candid responses, but rather investigative journalism generally. Dissent is 61 to 63. At this high level of generality, the dissent section 165 insists Section 165.540 does not prevent Project Veritas from engaging in investigative journalism of some sort. And it claims that we previously held that restricting unannounced recording does not foreclose the medium of investigative journalism. See Dietman versus Time Inc. 449, F2D 245, 9th Circuit, 1971. Dissented 55 to 56, 62, and number 11, 65. We disagree with this analysis. First, the dissent again fails to recognize the implications of Wasden. Under Wasden, the creation of unannounced recording of a subject's unguarded contact, which would include any statements made in the course of such conduct, is itself a form of protected speech and constitutes a significant medium of public expression. 878 F3D at 1203, citation and quotation marks omitted. As explained above, Section 165.5401C does not leave ample alternatives for Project Veritas's mode of speech. Thus, the dissent's argument that Section 165.5401C does not foreclose investigative journalism as a journalistic approach misses the mark. At some level of generality, art can be made without a paintbrush, but neither sculpture nor architecture is a substitute for painting. Moreover, the dissent's reliance on Dietman is misplaced. Dissented 55 to 56, 62, and number 11 and 65. In Dietman, two journalists used a ruse to gain entry to the plaintiff's home and then surreptitiously photographed and recorded him without consent. 449 F2D 245 to 46. We held that the plaintiff could state a claim for invasion of privacy under California law because the conduct occurred inside the plaintiff's home, ID at 248. And because the First Amendment did not accord newsmen immunity from torts or crimes committed during the course of news gathering, I did 249. But Dietman has no bearing on the question whether a rule prohibiting unannounced recordings in public places fails to leave open ample alternative channels of communication. For this reason, the dissent's argument that a parade of horribles will result from our analysis, such as an invalidation of eavesdropping statutes, is not well taken. Dissented 73. As explained, see supra section 3A, the threshold question is whether the challenge law restricts First Amendment protected speech. Under Wasden, the creation of unannounced recordings is speech protected by the First Amendment, but we are not aware of any cases holding that eavesdropping without more is protected speech. Therefore, the First Amendment would not constitute grounds to invalidate a statute prohibiting that conduct. Moreover, we analyze Section 165.5401C as a prohibition of the First Amendment protected speech in public places, see super section 3C. Our analysis of the state's asserted governmental interest and whether its restriction on speech is narrowly tailored would necessarily be different in the context of eavesdropping, where an individual's heightened privacy interests in his own home are at stake. Nothing we have said today impugns the well-established rule that the First Amendment does not accord a speaker immunity from torts or crimes committed in service of his speech. Dietman 449, F2D at 249. Footnote 20. The dissent argues that our conclusion that Section 165.5401C is not a valid time, place, or manner restriction means that the Oregon legislature is in a catch-22. Dissented 69, but a judicial determination that a statute is unconstitutional does not put the legislature in a catch-22 situation. Rather, it merely tells the legislature that its enactment has impermissibly infringed on First Amendment rights of its citizens. 2. Because we conclude that Section 165.5401C is not a valid time, place, or manner restriction, it cannot be saved by striking the two exceptions at issue here. Therefore, severability is not germane. Bernstein-Bro 661 P2D at 539. Furthermore, under outdoor media dimensions, we also conclude that the Oregon legislature would not intend the exceptions to be severed because the Oregon courts analyze severability. They assume that the legislature prefers to avoid enacting a bill that raises serious questions of constitutionality. State v. Borowski, 220 P3D 100 109, Oregon Court of Appeals 2009. If the exceptions were removed, Section 165.5401C would raise serious constitutional issues. This section would prohibit the unannounced recording of police officers performing their official duties or of a felony endangering human life. But we have consistently and repeatedly held that the First Amendment protects the right to photograph and to record matters of public interest. Askins 899 F3D at 1044, which includes the right to observe government operations. Reed v. Lurance 863 F3D 1196 1211 9th Circuit 2017. In the commission of a crime, see Obsidian Fin Group LLC versus Cox 740 F3D 1284 1291 to 92 9th Circuit 2014. Requiring a citizen to inform all parties involved to capture government officials' performance of official duties in public places, for example, would substantially impede the speech right by foreclosing a major avenue for citizens to gather information about government officials in an unaltered form that can readily be disseminated to others. Despite the fact that this type of speech serves a cardinal First Amendment interest in protecting and promoting the free discussion of government affairs. Glick versus Cuniff 655 F3D 7882, First Circuit 2011, citing Mills v. Abraham 384 U.S. 214 218 1966. Further, an announced recording of a felony in progress would not only tend to reduce the opportunity to capture such evidence, but also tend to imperil the person recording. Given the impetus for this exception was to enable police officers to make unannounced recordings of felony drug transactions and felonies endangering human life without first obtaining a court order, see Supra PP 8 through 9, the legislature would not choose to endanger police by eliminating this exception to the general rule. We're on page 42. Oh. The dissent suggests that removing the exceptions from the general prohibition in Section 165.5401C would not raise constitutional issues because a court would likely deem Section 165.541C unconstitutional as applied to an individual who filmed police or other matters of public interest in public places. Dissent at 68-69. But such a conclusion merely acknowledges that the general prohibition itself raises serious constitutional issues. Therefore, severing the exceptions that make the general prohibition content-based and extending the general prohibition to those protected First Amendment activities would create significant constitutional issues rather than cure them. Under outdoor media, we must presume that the Oregon legislature would not retain such a law. Okay, so footnote 21, the dissent argues that the legislature would want to retain Section 165.5401C as a standalone provision, even if the exception in Section 165.5405B for recording police officers were severed, because the general prohibition in Section 165.5401C was freestanding for 56 years before the legislature adopted the exception that allows the recording of law enforcement officers performing official duties in public. Dissented 51. He also dissented 67-68. This evinces a misunderstanding of the relevant legislative history. The legislature adopted Section 165.5401C long before Fortitude made clear that such general prohibition on filming matters of public concern raises serious constitutional questions. See 55 F3D at 439. Following Fortitude and subsequent opinions reiterating this rule, the legislature added the exception in Section 165.545B, likely to eliminate this constitutional concern. Unfortunately, the addition of this exception renders Section 165.540 a content-based speech restriction, which created a different First Amendment issue. Given that the Oregon legislature already evinced its intent to avoid the constitutional questions raised when Section 165.541C was a standalone provision, we must conclude that the legislature would not sever the exception in Section 165.5405B, which would merely bring back to life the same constitutional issue that the Oregon legislature faced prior to enacting this exception. Okay. So we're on to the last paragraph of the case on the prevailing opinion, the majority opinion. Okay, I lost my spot again. Where we go? Let's see, we're about 40 something. 41, maybe? Okay, reversed and remanded. So here's the last paragraph. Reading section 165.5401C as a whole, we conclude that it is content-based speech restriction and cannot survive strict scrutiny because Oregon has not asserted a compelling government interest and because the statute is not narrowly tailored. The statute is also not a valid time, place, or manner restriction because it does not leave open ample alternative channels for communication. Applying Oregon law, we must not sever the exceptions because severing them would not render section 165.5401C constitutional. Accordingly, we conclude that the statute is facially unconstitutional, reversed and remanded. Okay, so here's the thing. I'm on page 43 of 78. I thought about coming back later to read the dissent. I don't really care for the dissent, and it's shorter. Oh, I'm terribly tired, and my voice is going to go very hoarse. It's very hard to do. Oh, and I thought I should just keep going. Christian Circuit Court, a circuit judge dissenting. The right to, okay, so this is in defense of protecting these restrictions. Let's see. The right to speak and publish does not carry with it the unrestrained right to gather information. When it, yeah, I'm just wrecked, tired. I'm so sorry, world. I'm tired. Oh, hey, everybody commenting. Sorry, that was a boring court case. It means you get to film corruption in your neighborhood. Go film corruption in Oregon. It's a really good court case. Veritas v. Schmidt. They sued to protect the right to film corruption.